Hello, Sandra Fuentez with Fuentez Law. If you can't make up, we'll help you break up. One of the most commonly asked questions is what age can a child decide who they want to live with? In Texas, the age is 12. When your child's 12 at least or older, they're able to express their preferences to a judge. So whether it's a suit that you're currently in the middle in and it's the beginning, like you're just going to be making some custody orders, or whether you have prior orders and your child now is 12 and has a preference to where they want to live, and you're going to be seeking to modify because of the preference, because other things are happening also, then this is when this would apply. So you would file the motion for the judge to confer with your child, and then the judge has to speak to your child. Before the age of 12, you can still file that motion, but the judge does not automatically have to speak to your child. It's a discretionary whether the judge thinks that it merits speaking to your children, because typically judges don't want to involve children in any type of court proceeding, and talking to a judge is really putting them in the middle of the court proceeding, right? So Texas thinks 12 and older is enough mentally that a child is able to comprehensively express to the court their preferences and their reasons why. And so typically how it happens and when it happens is after a court hearing or after a trial, after the judge has had the ability to hear the testimony of all parties as to the reasons why they think they should be primary custody, why they think it would be bad for the child if the other parent was primary custodian of the children. After they hear all that and they hear the evidence and see the evidence, then they're able to be in the position to speak with your child, because they've heard what the parents are saying and what the parents have shown as proof. And now they can speak to the child and through a conversation sift through which parent was actually more on point than the other, which maybe was even lying from what the child may say, and be able to make a decision also keeping in mind your child's preferences. And so it typically is only one time too. It can be more than one time. The judge could speak to your child during the middle of the pendency of a case for temporary orders, and then decide that they're also going to speak to them on after a final trial, if you go to a contested final trial as well too, just to ensure circumstances have stayed the same or if something has changed. So it is important what your child has to say. In my experiences, judges really do try to respect a child's wishes within reasonableness, right? They're not going to, because this is simply the fun parent, but the fun parent has a substance abuse problem, they're not going to switch it to that because of the substance abuse problem. So it's important you have a good lawyer who's able to show the evidence of what may or may not be in the best interest of your child too, because that is foremost, as I discussed on my channel before, the global standard for custody of children in Texas is the best interest of your children. So if you like what I had to say today in this video, or you like the content, then please like this video and also subscribe to my channel. Bye.